Members, we now have a quorum. Let's get started. Today we have an open hearing to receive public views on Law Reform Commission's consultation paper on sexual offences involving children and persons with mental impairment. And we have shared paper number CB-4591/1617-04, which is an executive summary of the consultation paper. Let's welcome members from the Law Reform Commission of Hong Kong as well as deputations.
請大家揾到自己嘅團體嘅名字，可以先坐低曬，揾到自己嘅位係啦。而家有9個嚟咗，係咪？係，首先歡迎大家先嚇。
Welcome. Let's invite members of the Law Reform Commission as well. We have 17 deputations who have signed up. Now, 10 of them are already here, and they might come in one by one. First of all, let's welcome the deputations and the Law Reform Commission. Today, we are receiving public views on Law Reform Commission's consultation paper on sexual offences involving children and persons with mental impairment. If needed, you can put on the headset and choose the channel. Channel 0 is floor, Channel 1 Cantonese, Channel 2 English, Channel 3 Putonghua. If necessary, our staff can render support.
For simultaneous interpretation for Putonghua, English and Chinese. 跟住呢就係特權及豁免嘅內容。我首先
I'd like to remind attending officials and deputations that your speeches and submissions will not be protected by the Electoral Powers and Privileges Ordinance and the relevant exemptions. I'd like to remind members of the note for members of the public attending meetings in conference rooms or observing meetings in public galleries in the electoral complex and the relevant security measures. The note has been attached in the bundle to deputations shared by the Secretariat, and it has also been tabled. Members in the public gallery can also receive a copy of the note from the security staff. I will now invite the deputations to speak one by one, and each will have 3 minutes. We will stop you after 3 minutes. The panel has also uploaded your written submissions to the electoral website. Since time is limited, please be concise when you speak. And there's no need to repeat all the content in your submissions. If you have yet to submit your comments or written information, please provide them after the meeting. When you speak, please do not speak in both Chinese and English. When the bell sounds, please stop speaking. From Amnesty International, Ms. Choi, please. Thank you. Amnesty International Hong Kong has a few comments. First of all, the Subcommittee on Review of Sexual Offences under the ARC was established in 2006, and 4 consultation papers were promised, but this is only the second paper. Progress has been very slow, and legislation is also behind schedule. We urge the ARC to establish a timetable for drawing up the reports as well as expediting the review on sexual offences. And the guiding principles of a reform are based on the Civil Rights and Political Rights Convention. And right now, 7 core international human rights conventions apply to Hong Kong. And this reform is also related to PMIs. And any law reforms should be based on the overriding principles of the core human rights conventions applicable to Hong Kong. And we welcome respecting the sexual autonomy of PMIs, but some recommendations might affect the sexual autonomy of PMIs. And as a starting point, we should follow the principles of the Convention of the Rights of People with Disabilities, and PWDs should enjoy equal legal rights. Sexual education is also very important. We urge the government to respond to the UN decision and enhance sexual education in campus and for the mentally handicapped, and they should understand what is meant by sexual autonomy. And the sexual education should be conducted based on age, and we should embrace sexual diversity, health, etc. Thank you.
Thank you, Ms. Choi. Next, we would like to invite Ms. Chen Shi from the Anti-Sexual Violence Resource Center. We would like the 2 main submissions in respect of the report. In the consultation paper, it is suggested that sexual offences involving children I think we should abide by the principle of respecting children and women, and we believe that this is a major improvement. But we would like to know that while respecting the autonomy of children and women, we are worried that sex education is outdated. And when we allow children to exercise their autonomy, would they be able to exercise their autonomy and come up with the right decision? For example, sexual education regarding, for example, it's not detailed enough. So children actually may not be able to make a decision regarding consensual sex. So while we respect their autonomy, can they really genuinely exercise their sexual autonomy? In order to plug the loophole in the law, the committee must, other than proposing the legislative proposal, it should also suggest that government should step up sex education so that principle could be upheld. Secondly, according to the consultation paper, there is a proposal that we should standardize the age of consent. While we agree with the proposal, but we have reservation about setting it at 16. The age of consent set at 16 has been adopted for many years. But after we look up the records, we've not found the government having done anything about any information regarding sexual behavior of young children. In 2011 and 2013, the Family Planning Association and the Hong Kong Polytechnic University and another academic institution have conducted studies and found that the age of consent is actually lower than 16 as recommended in the paper. To respond to social aspirations, since so many years have lapsed already, we need to look at the social context and decide whether or not we should still, set the age of consent at below 16. We hope that the government will conduct further research on this topic so that the age of consent can really protect young people and adolescents and also take care of the developmental needs. Thank you, Ms. Chan. Next, we have Mr. Yip Chun Yun from the DB. Regarding the proposal from the Law Reform Commission, the principle of protecting children according to the law, the DAP basically support such proposed reforms in the law. Regarding the proposals of the LRC, again, we would like to express some concerns and make some comments. Regarding recommendation 6, that is for children between the age of 13 to 16 and the legal liability should they commit sexual offences. We wonder when we adopt absolute sexual liability, we should not differentiate between penetrative and non-penetrative, sexual offences. I think the focus should be shifted on to protecting the extent of protecting young children. I think young people are now more precocious and because of the availability information, young children have now become more curious. So we already have a consensus on age of consent on the premise of protecting children from being sexually exploited. We believe that for children between 13 and 16, any such offences, I think we should impose absolute legal liability. And regarding the 8 proposals regarding how sexual offences should be handled, we believe that the current prosecution mechanism is appropriate. In this regard, the prosecution should be able to exercise discretion to deal with, sexual behavior between children of similar age based on consent. More and more young people are now involved in sexual activities, but in order to protect our children and adolescents from being sexually exploited and also not encourage children and young people before they are mentally matured and don't know about the consequences to be involved in sexual activities, the DAB believe that the prosecutional discretion should be left with the prosecution, which is much better than the two other alternative methods proposed in the report. Regarding recommendation number 6, whether or not we should eliminate the defense of a marital relationship, although it's very seldom that people marry under the age of 16, but the DAB is concerned that after the amendment of the law, whether or not for our ethnic minorities, if they go back to the native countries and marry according to the customs of their own country, whether the reform will have any impact on them. Because if you scrap the defense of marital relationship and if you impose an absolute legal liability, some legitimately married couples, even if there is mutual consent when they engage in sexual activity, they might also, be in breach of the law. And finally, in respect of Chapter 11 of the report regarding sexual offences of MIP, the AP strongly, support the proposed offences and the penalties because the mechanism for checking the register of sexual offenders. Sorry, your time is up. Next, we have Ms. Choi from the Association Concerning Sexual Violence Against Women. I think we've already made our submissions to the Law Reform Commission. Today, we'd just like to highlight a few points. Last time when the LRC convened a public hearing on sexual offences, it was the 8th of January 2013, namely 4 years ago. Now, the subcommittee on review of the sexual offences have been set up for 11 years, and since then they have published 2 consultation papers. They've also published other consultation papers. There are 2 consultation papers which have yet to be released. Of course, when the committee was set up, sexual offences in Hong Kong, I think compared with other jurisdictions, our laws are already 20 years behind. We are still only publishing your second consultation paper, so we are already 30 years behind. So we would like to request that the Subcommittee on Sexual Offences to LC should expedite the pace of the report, the review, and complete the consultation as soon as possible and submit all its reports ASAP. Secondly, we also agreed that the age of consent should be standardized and that there should be any differentiation between the 2 genders. And with as society develops, as someone pointed out, children under the age of 16, it is not uncommon for them to be engaged in sexual activities. Relying on a law to ban that is not practicable. This is a reality, and you cannot resolve the problem simply by prohibition. The government should therefore conduct periodic studies in respect of sex education, gender education, and whether or not we should lower the age of consent. Without such information, we would not be able to discuss the way forward for our future sex education and also whether or not we need to lower the age of consent. Thirdly, regarding MIPs, sexual offences involving MIPs, the mental health ordinance plays an important role here. But that ordinance actually, mix up the MIPs and other mental mentally handicapped persons or those who are disorder. So it has not taken into consideration the complexity of the two types, two different categories of persons, and have not taken it on board into consideration the complexity of the different types of mental diseases. Mixing up the two groups would not be able to resolve the question regarding the definition of MIP, and if that, we will not be able to come up with the supporting measures. Without the proper definition, we will not be able to come up with the supporting measures. Where we are faced with the threat of sexual violence, and since the witness is someone who could be easily hurt, the LLC should consider how we should deal with hearsay evidence, and also we should change the rules and how we can help the MIP to be able to get support at the front line. Finally, I hope members will note that there is LLC of the community, and they have published a report regarding witnesses who could be easily hurt, and I hope members will refer to its recommendations. Next, Mr. Lee Shu Wan from the Hong Kong Bar Association.
Madam, for most of the recommendations in the report, we take the view that they are social issues, such as what the age of consent should be, whether there should be new offences to protect the children or persons with mental impairments. As such, we take the view that these issues should be put to the general public for comments. The only one concern the Bar Council has, for the time being, is in relation to the issue of absolute liability under Chapter 4, and in particular in paragraph 44 of the Executive Summary. I think we should be careful when we decide whether we are to put the consent or the mistaken belief issue as part of the elements of the offense, or it is simply to put as a defense available to an accused. As we all know, this is a departure from the general principle that the prosecution should bear the burden of proof, and unless there are exceptionally good reasons, we should not too easily depart from such norm. That's pretty much the position of the Bar Association for the time being.
好，多謝你 Mr. Lee。
Thank you, Mr. Lee. Next, we have the Dr. Cheng from the Hong Kong Psychological Society. Thank you. I represent the Hong Kong Psychological Society. Our society was set up in the 80s. We're the largest psychological society representing 490 clinical psychologists. We agree with Proposal 1 and 2 of the committee, that is, we should standardize the sexual sexual behavior based on consent at 16. We do not agree with Recommendation 3. That is, we don't think we should differentiate the sexual offences based on the age, because the hurt caused by sexual offences are the same. Recommendation 5, we agree that we should sexual offences, we should not differentiate between minors and adult child offenders. We also believe that there should be mandatory requirement for mandatory treatment for sexual offenders. Recommendation 6, for sexual offences involving children between 13 and 16, we believe there should be an absolute liability, because this can means that they don't need to testify in court. Testifying in court would cause secondary traumatization for these witnesses. If it is inevitable that they must testify in court, we propose that the court should allow parents or adults they trust to accompany the victims to testify. Regarding Recommendation 8, that is, for those between the age of 13 and 16 who have consensual sexual activity, we believe that this would also be criminalized. But when we come across such cases, in the course of prosecution, the prosecution may consult the views of clinical psychologists. Regarding Recommendations 9 to 22, we agree with the recommendations of the committee. We hope that we can implement the recommendation as soon as possible, because the current laws fail to reflect the seriousness of certain sexual offences, for example, certain non-penetrative sexual offences or pedophiles. Recommendation 23 to 25, we agree again to those recommendations. We agree that we should, that is for that the protection of persons with mental impairment should be included under the sexual offences. Regarding the definition of mentally incapacitated persons, only clinical psychologists have the expertise and the training. But the mental health ordinance and the crimes ordinance have not recognized or accept the diagnosis by qualified clinical psychologists. We hope that the LRC will explore this issue further. Thank you very much, Madam Dr. Chang. Next, we would like to invite Ms. Dr. Ho Ai-ji from the Against Child Abuse.
We have 8 recommendations. First of all, we support the principle of protecting children, and we should enhance rehabilitation for sexual offenders, and there should be absolute legal liability on offences involving children between 13 and 16, and there should be protections to avoid early sexual behavior. A lot of young persons are not mentally mature, and they might be curious, and they might fall into legal traps, and they need guidance and protection. And we need to enhance support on juvenile sexual offenders, and when exercising discretion, specific information should be provided to enhance the consistency of the handling. And in terms of criminal liability, and the bar should be raised from 10 years old to 14 years old. And we support gender neutrality, and a lot of protections currently only apply to women but not men. So we should protect both female and male victims. As to the LRC's proposed sexual offences, we support them, and we suggest introducing a new offence called sexual grooming to avoid grooming children through mobile phones or social networks with the purpose of committing a sexual assault. And in recommendation 11 and 12, touching of a sexual nature is rather unclear. And in recommendation 40 on whether we should protect young persons above 16, according to the UN Convention, children are defined as persons under 18. There should be legal protection for children between 16 to 18. We hope the LRC can also come up with infographic consultation papers so that the public can understand provisions of the ordinance and offer their views. After establishing the laws, the government, the LRC should use the media and schools to educate the public. There should be a inspection mechanism on conviction of sexual offences. The government should put in more resources to make the relevant mechanism statutory in nature, so that employers and employees can inspect the records. For private tutors, I think this is especially significant for parents. There should be mandatory therapy services for convicted sexual criminals, and consultation should be given to child victims, and an independent children's commission should be set up to establish long-term policy and indicators. And Mr. Chen Sai-kit from the Democratic Party. Thank you. I'm also a registered social worker. The DP has been concerned about sexual offences against PMIs. We have been looking at some sexual assault cases at the Bridge of Rehabilitation Home and another care home. The current legislation is outdated. the current legislation on sexual offences was established 50 years ago, and they should be updated. We welcome extending the legislation to all PMIs so that the courts would have more flexibility in dealing with sexual offences against on PWDs. On the earlier consultation by the ARC, we have a few recommendations. First of all, we agree with unifying the consensual age at 16 years old, regardless of sexual orientation and gender. I think this should apply across the board because this would be embrace equality. We should amend 2 offences for children under 13 and 16 respectively, and we also agree to the recommendations because this would reflect the offences against these 2 types of children. There should not be overlaps between different offences, and in the consultation paper, absolute liability was mentioned. Should there be absolute liability for offences on children between 13 to 16? There should be more discussions in the society. The DP feels there should not be absolute liability for children between 13 and 16. In terms of psychology, children would become curious in sex during puberty, and we should protect children against sexual deprivation. But if we hold them liable due to their curiosity, we would affect their sexual autonomy. So we should reinforce sexual education in Hong Kong. As for consensual sexual activity for children between 13 to 16, they would be criminal, but the prosecution can exercise discretion when making charges, and we have reservations towards this recommendation. We feel the prosecution can exercise discretion, but since we are dealing with children who are underage, they should be freed of the criminal liability. I think we can learn from the provisions in Taiwan. Hong Kong needs to reinforce sexual education. Thank you. Next, from the Civic Party, Mr. Zheng Kuan-Hiu.
Party agrees with the general direction of the LLC to amend crime ordinance to better protect children and persons with mental impairment from sexual exploitation. And the Civic Party is also aware of the current law being outdated, overlapping, and discriminatory in many areas, and therefore supports the LLC's position that a more comprehensive legislative regime should be implemented. And this is especially compelling in light of the recent incidents involving victims of sexual offences who are mentally incapacitated, such as the incidents of the Bridge of Rehabilitation residential home in late 2016. And CP has no major comments for the LLC's recommendations, except for the recommendation 8, that CP agrees with the current proposed to reject an express close age exemption or defence, as this will lessen the protection afforded to young persons. And the accused or the victim having similar age or that they are in puppy love do not literally mean that the sexual activities are conducted on completely voluntary or consensual basis. CP, however, agrees that the close age between the accused and the victim should be included as a factor in the guidelines for the prosecution to take into account in considering whether to bring about prosecution. And also for recommendation 6, the CP suggests that considerations should be given to the Canadian approach, where the defense of honest and reasonable mistake is only available when the accused has taken reasonable and sufficient steps in all circumstances to ascertain the victim's age in sexual offences involving young persons between the age of 13 and 16. And this may provide a good balance in protecting children and ensuring the constitutional rights of an accused not being infringed. And also finally for recommendation 40, that the CP suggests that research should be conducted to assess whether cases where a person in a position of trust exploits a child between the ages of 16 to 18 years old are prevalent in Hong Kong. This could shed light on whether there is a need to introduce such an offence to Hong Kong. And finally, CP welcomes the recommendations suggested by the LLC and wishes to see the relevant legislative proposals be introduced to the Legislative Council in a timely manner. Thank you.
好多謝張生，跟住落嚟呢，就係卓新力量。
Thank you very much. From Chosen Power, Miss Tam Carmen. The mentally handicapped and autistic persons feel that all law reforms should take reference to the principles of the UN rights for disabled persons and the below provisions. Reports and the general comments on various provisions. On term provision 12, the right to be acknowledged equally before the law, and Article 13, the right to be legally protected, and Article 14 and 15, as well as Article 16, as well as 17. We have attended the UN, the lobbying and open hearing sessions at the for the UN Children's Convention, Women's Convention, and Convention Against Torture. Apart from the Hong Kong laws, we have to consider the latest recommendations on international human rights in which Hong Kong are a party. We agree with removing the description of mentally incapacitated persons or MIPs to restore our dignity. You should adopt neutral terms. If we are to learn from the UK, we should look at how they offer support policy through the human rights perspective. Legal justice is not just for children, the mentally handicapped, and people with different mental abilities. Our parents do not know the law, and we lack information. In order for us to enjoy legal protection, apart from amending the ordinances, you need to promote publicity as well. Finally, please provide simple graphic versions of all consultation papers. And you need to embrace the convention principle of information accessibility. And you should renew the legislation by considering human rights. And we need to participate in our issues. Thank you very much. Ms. Ngao Yim Fong. Good morning. As a parent of a mentally handicapped person, I support the ALC's recommendations. I've attended different public hearings, and the consultation papers are complicated and they use a lot of jargons. And my Chinese is not good enough to understand everything. If you are to really listen to parents, children, and people with different levels of mental ability, the ALC should introduce briefings to explain the information in an easy-to-understand manner so that we can truly participate. the UN Convention for PWDs have been exercised in Hong Kong for more than 10 years. I wonder if the ARC's legal experts have paid attention to the convention principles and below terms, as well as the comments on the convention and those in 2012. You have to take reference to the below terms. Tam Kamen talked about Articles 12 and 13, and Article 14 is about freedom and personal security, and Article 15, prevention of torture, cruelty, and inhumane treatment, and Article 16, protection against deprivation, violence, and torture, and Article 17, bodily integrity. I attended with my daughter a UN Women's Convention lobbying and hearing. I urge experts, legislators, and government officials, if you are to amend the law, you have to refer to the latest recommendations of International Human Rights Convention, in which Hong Kong is convention.
We agree with scrapping the terminology of MIP. We believe that all of us have the ability, we all have the dignity, and the law must respect our legal capacity and status, and therefore you need to review the term MIP and adopt a more neutral term. You should make reference of the practice in the UK and learn from how they would enact legislation and provide support measures from the human rights angle. Judicial justice is not just for children, the MIP, and the mentally incapacitated persons, but rather protecting everyone in society. The parents don't know about the law. The welfare worker, social workers also don't mention that. So it is, unimaginable for the law to protect our children. Other than therefore reviewing the law, we should do more in terms of promotion and public education. Finally, all the consultation papers should be also published in a simplified pictorial form, and you should also implement the International Covenant on the Protection of the Disabled Person. You must review the law based on, the principle of upholding human rights. Next, Mr. Leung Hoi Fu, Chairman, Madam Chair. We are one of the advanced countries in Southeast Asia. We hope that our legal system will change with the times. Unfortunately, our crime ordinance only has an offence for men involving in sexual offences against women. This is not equal. Even in China, we do not see this anymore. And it's because of this piece of legislation, many people in Hong Kong have the impression that women is always the victim whenever there is a sexual offense, and the man is always the stronger party, and it is always the person who is the perpetrator. Madam Chair, so now because of this piece of law, we have this sexual gender prejudice. So in the current proposal for reform, I fully support and demand that we should not have any differentiation based on gender, sexual orientation, and the mode of sexual intercourse. They all should be standardized. And I also agree that there should be a standardized age of consent and lower it to 13, and there shouldn't be any room for discretion. Because any discretion is like the other laws in Hong Kong. I mean, just imagine, how the CPVC's Standing Committee interpret the basic law. So I think we need to adopt, a standardized age of consent of 13. Some people may argue that you're not yet mature at this age to be able to know the consequences. That's all right. But because of that, I would propose that for children under 13, they cannot accept, for example, any drilling in school. Would you agree with that? If you cannot, sustain we are not ready for sexual intercourse or sexual contact, then the children may not be able to without the pressure of all the drills for the BCA and TSA. And many young children, young school pupils may benefit, so they don't need to worry that they will be actually, manipulated by social workers. For disabled persons or people who are physically challenged, if they're involved in sexual offences, other than offering more protection for the vulnerable, I also agree that they should also have sexual autonomy like ordinary people. They should be able to enjoy the autonomy to enjoy in intimate, sexual, activities. Ms. Lam Sin Man, Madam Chair, over the years in Hong Kong, we have not had a public consultation on this subject, and all these ordinances are already out of date. We have seen many problems now in society. Many of the victims dare not even report the offences. Many young children who are victims dare not speak out, and even the parents dare not, report the offences to the authorities. So who is there to protect our children if our laws are not, sound enough? So I think we should have more consultation and also make reference of the practice in other jurisdictions, so that information is widely available nowadays, and the children sometimes know a bit of something and there are other things that they don't know. Our education system is also very backward. Why is it that we are so backward in terms of sex education? Why is it a taboo even for parents, and they don't even know how to educate the children? So I think these are the areas where we need reform and public education. Furthermore, if there could be a mechanism to allow people who provide, organizations providing service for children, like tutorial schools, custodian institute, homes, and so on, so that parents can have the confidence to place their children there and go to work. So, is there a mechanism to check whether or not the carers have ever been sexual offenders? For young children, if they are precocious or if they're not yet mature enough, and then they commit a sexual offense, how do we determine whether the penalty that should be imposed on this young person? I don't think there should be a standard approach, because some children are very mature, others may be very ignorant or don't know everything and thought that they're already an adult, and think that they're already adults, and again, this is something we need to look at. We need to look at the physical age and the mental age of the children. For the general public, again, we have difficulties reading your consultation paper. We're not experts. We don't really understand too much the jargons that you use. If you could use simple language, or better still, it would be best if you would present your consultation paper in both, verbal and pictorial forms. I would now like to invite the members of the Law Reform Commission, Mr. Ross, and also Ms. Ng, to see whether or not you have anything to respond or respond.
Thank you, Madam Chairman. There's a consistent theme through the the responses from the deputations that the information and the recommendations made in the report.
Yeah, Mr. Ross, can you speak closer to the microphone, please? Yeah.
There seems to be a theme, Madam Chairman, that the information contained in the consultation report is not easy to digest, and it may best be shown and demonstrated more easily through a pictorial or through a graphic or through an information diagram. It's a very useful suggestion, and I'll take that back to the subcommittee. It seems quite a good thing to do, because this is a big review, and it's difficult to come to grips with all the recommendations in a digestible form. The other matter that I should refer to is another couple of deputations referred to the progress made by the committee in the subcommittee in its deliberations. If I could just give you a short history of that. The subcommittee was actually formed in 2006, and in July 2008 a consultation paper on the register of sexual offenders was prepared and reported to the government. A report was made to the government in February 2010, and administratively a register was implemented. This was all through this committee, through the subcommittee, and the register was implemented in December 2011. In December 2010, a further report was prepared by the subcommittee on the abolition of common law presumptions that a boy under 14 is incapable of committing sexual intercourse. And the result of that report was an amendment to legislation in 2012, and was enacted in July 2012. Came into force rather in 2012. In September 2012, there was a consultation paper, the first consultation paper on rape and other non-consensual sexual offences. And in November last year, this current consultation paper was prepared. And as the deputations mentioned, this is one of 4 reports that will be prepared as part of the overall review of the topic of sexual offences. And the view taken by the committee is it's best, because it's such a large topic, it's best dealt with in terms of 4 separate areas, and left to the and a consultation paper produced after each of the 4 sections, so the public and members can appreciate the work we're doing and make representations about it, about each of the reports. As I say, this is the second one. The third one will deal with miscellaneous sexual offences, things, and we're working on that now. Consider things like unusual things such as necrophilia, exposure, sexual exposure offences, grooming and the like. And the last report will deal with sentencing, looking at whether the sentences are appropriate when we compare the offences, whether the degree of culpability reflects the sentences that are currently there or the sentences that are to be proposed. And lastly, whether when a court is sentencing a sexual offender, whether the courts have sufficient powers to deal with the offender. Should there be additional powers given to courts to order treatment on offenders, things like that? That would be the 4th consultation paper. There's been a number of comments about whether the liability for offences by towards victims 13 to 16 should be absolute, or whether there should be a defence based on a reasonable mistake as to the age. And as you'll see from the report, we're very much divided within the committee as to what the position should be. So we're very appreciative of the views expressed by the members today and the deputations as to what that should be. The member of the Bar Association should suggest perhaps that there is a concern about whether the defence, if there is to be a defence, should be part of a defence, or whether it should be an element in the offence to be disproved by the prosecution. And we'll take due note of that and discuss it further in the subcommittee. I think that's all the comments I have at the moment.
Okay. 其他兩位有冇 any more?
Do the other representatives have any further comments? If not, then I will now invite our members to ask questions. I'd like to remind members that pursuant to Rule 83A of our Rules of Procedure, if members of any direct or indirect pecuniary interest in relation to the issue we're discussing today, you would need to make a declaration accordingly. Now, any members who would like to ask questions? We have 3 members so far. Shall we say 4 minutes for each member, starting with Mr. Ray Chen? Thank you. I have heard many deputations telling us that the project of the LRC Well, it was set up in 2006, and we're now already in 2017. They've now just published a second consultation paper. I understand that many of those on the LRC are volunteers, and they need to be engaged in this meticulous task, and in each meeting they can only discuss a few issues. The consultation paper and the recommendations is very complex. I have to spend a lot of time digesting the contents of the paper. But all of us would like to know whether or not there is a timetable. We know that our laws are outdated. You are able to identify the issues, but if you're able to identify the issues and then you're not able to tell us when you will take action, and we have to wait for all the 4 consultation papers have been completed, would that already be even after 2020? Because we still have to wait for the government to draft the bills, and from the time it's submitted to this council for vetting, you could imagine how long it would take. Could we first instead deal with some of the issues which are not controversial?
As to the issue of consensual age, I think the majority would agree setting the consensual age at 16 regardless of gender. Some people also suggested a review. If we are to lower the consensual age to, say, 13, suggested by some deputations, this would be very contentious, and it would take a long time from the LC's recommendation to the government implementing it. We might need a number of years. And under recommendation for the definition, children is 18. But what about children aged 17 to 18? And the ALC has no comment on that, and they would leave it to the public to make a decision. I think we should unify the age at 16. If you need a separate set of laws for those aged 16 to 17, it might be rather cumbersome. Well, if you wish to do that, you might as well reinstate the age of 18. I think the deputations can comment on that later. And under recommendation 8 for consensual sexual activity for persons who are underage, and there are a few recommendations. Criminalize with discretion and non-criminalize, and most people would go with the first proposal. I think we should be more lenient. I have seen some cases of consensual sexual activity between young persons, and the parents and social workers wanted to take a charge against one another. And there were people who don't want their children to be hurt, and by taking out charges against each other, the process is very painful and traumatic. If we can be more lenient at these cases, that might be better for children or both sides. At the end, perhaps what would that be the one direction we would go? I would allow time for deputations to respond afterwards. Next, Dr. Fernando Chang. First of all, I'd like to thank the deputations for being here. Apparently, the general view is that the reform is too slow, and it's rather imminent for issues like sexual autonomy, sexual orientation, sexual discrimination. All these. In all these areas, Hong Kong is lagging behind. And we need to have a reform urgently. We have so much resources in our society, and we have so much money on infrastructure projects, but for this, we apparently lack resources, and the ALC seems to be very short of hands, and even after they came up with recommendations, the government can ignore them. And now 80% of the ALC's recommendations have gone unused. We don't have anyone from the government here today. The deputations have spoken, and well, we are looking at complicated or even controversial issues. And the government would say that they would wait until we come up with a consensus, and there would be the work would be further delayed. I appreciate the ALC's efforts, given the lack of resources, because they have tried their best. But this is not a serious law reform exercise. The ALC should drop a timeline for themselves and the government. We have a lot of legal experts, so we should set some deadlines for the government. We should ask them to implement the law reform. So I think the ALC should draw up a timetable. I'm quite concerned about mentally handicapped persons or MIPs. And this report is about PMIs. And this is a rather medical term in nature. So can we use a better term or definition? Rain Lilly talked about mentally handicapped and persons with mental issues. I think we should look at this. For PMIs, for a mentally handicapped person, does he or she be able to give consent? There are three conditions. First of all, is the person does the person understand what the behavior is, and second, can he or she make a decision, and three, whether he or she can convey such decision. For the bridge of rehabilitation incident, and the original decision was that the intercourse must be illegal as long as it involved PMIs. But after the reform, we must first ask the victim these three questions. If the victim is able to express the answers, we then need to prove he or she does not consent to the intercourse. So for the mentally handicapped persons, we have a lot of borderline cases. Then it's both a yes and no. So it's hard to balance the interests, and there would be difficulties in the actual execution. We hope the LLC would look into the protection. Thank you very much. Does other member wish to speak? Now it's my turn, and Ms. Holden Chow, please go first.
I think I agree in principle that introducing the absolute liability to the sexual activity upon the kids between the age of 13 and 16 could be able to further protect the child, especially to avoid them to give evidence at trial. So I agree in principle that having the absolute liability would have that sort of upside. But on the other hand, I would also agree that for the penetrative activity and also the non-penetrative activity, so people might probably hold differing views. So I would agree that we should consult the public further on that particular issue. And I think that's my opinion. Thanks. Thanks, Charity. Thanks.
All
right. I have some questions as well. The deputations gave some very good views, and under recommendation 8, for consensual sexual activity between persons between 13 and 16, I think gender equality is very important. And nowadays, young people mature early. For those who are age 18 compared with children who are age 13, 20 years ago, children nowadays are much better educated. For consensual sexual activity between young persons or between persons that are in love by adult standards, they should not have to suffer criminally or suffer criminal records. We have all seen such cases, and the persons involved are under great stress. So how would we deal with these cases? Where do we draw the line as to these when we make these activities criminal? I think these warrant further study. And for other offences such as grooming or induction, I think different treatments should be given. Today we talked about the incident at Bridge of Rehabilitation, or cases involving mentally handicapped persons and how they can express consent. I hope LIC can offer more views on that. They might have difficulties expressing consent or non-consent. Well, we need to strike a balance here. We don't want to affect innocent people. For people who can or cannot express consent, how would we deal with them? How do we deal with hearsay evidence? For cases like Bridge of Rehabilitation, I have not really heard any specific solutions or recommendations on how we deal with these issues. I agree with introducing a timeline. We should first introduce gender equality. So I hope to take in more views from the ALC and deputations. Mr. Ray Chan and Dr. Fernando Chang asked some questions, so no one else is in line. So if you wish to respond to members, feel free to do so.
Give some response to our questions.
Thank
first.
you.
Yeah.
Thank you, Dr. Leung. The Mr. Ray Chan and also Dr. Fernando Chan, that the progress in producing the reports is too slow. The subcommittee's plan actually is to have one global final report based on the 4 individual reports that I mentioned before. And in preparing the final global report, we would take into account the public's views collected in respect of the 4 consultation papers. So with that in mind, it's difficult to put forward a time frame because the consultation period for each of the 4 individual papers will take some time to receive and to digest by the subcommittee. And given that the final report will not be made after the 4 individual ones, and that we've got 2 consultation papers to go, it's somewhat premature at this stage to lay down what an actual deadline could be. But be that as it may, you can be assured that we're fully committed to producing these proposals as soon as we can. Mr. Ray Chan indicated that some of the members are voluntary. In fact, apart from the support staff doing the actual administrative work, all the members in the subcommittee are voluntary, headed by a senior counsel, Mr. Peter Duncan. And so that we're all part-timers, so the resources that we have available to us are somewhat limited, except we've got a full-time support staff to provide administrative backup. But we are fully committed to producing the 4 reports as soon as we can. Another issue raised was the recent rather recent sexual assault case that was discontinued by the Department of Justice at a residential care home. I have to say that the terms of reference of the subcommittee...
Sorry, Mr. Ross, can you speak closer to the microphone, please?
I have to say that the terms of reference for the subcommittee is a review of the substantive law governing sexual and related offences under Part 12 and Part 6 of the Crimes Ordinance. So actually, the reform of this area to facilitate prosecution in that particular case would be actually outside our terms of reference. There has been a report in relation to hearsay in criminal matters, and that may impact on a possible solution in this particular case, which is not this subcommittee's terms of reference. But could I pass you to Michelle Ainsworth, the Secretary of the Law Reform Commission, who can give some input on the previous report on hearsay?
Okay, Michelle, please.
I can report that the Department of Justice has just in the last month released a consultation paper on a bill to implement the hearsay report, which was published in 2009. So there is definitely some movement on that we can report. Could I also just add to supplement Mr. Ross's comments? We will certainly reflect back to the Commission the concerns about being able to set a timetable, and also the concerns from the deputations about providing more user-friendly reports. It is difficult, unfortunately, with something of this complexity, where there are a number of detailed legal issues that are being addressed. But we will certainly take that on board and see where we can revise the way that we're producing our reports and promoting them. If I could also just add, in relation to the concept of producing a global report on this particular topic, because it's a review of overall sexual offences, it was, I think, understood by the subcommittee that because of underlying themes which are running through much of this area, in order to maintain consistency, there was a plan to produce the reports in sequence and to allow the public to come back with the views so that they could modify the approach as they were going. So that was, I think, the intention behind producing a global report at the end. But again, we can certainly take the concerns that have been expressed back to the Commission.
Okay. For public consultation, there are a number of groups who would like to get a simplified version.
Yes.
So you are going to do it?
We will reflect that back to the Commission, yes.
Okay. 或者睇下團體會唔會有
I'd like to now ask whether the deputations have anything they'd like to say in response. I'd like to give the rest of the remainder of the time to the deputations. Could you all put up your hands so that I can, all of you? I think in that case I can only allow you 1 minute each, because several members would like to go for the second round of questions. So we set the time for 1 minute first for each deputation. Starting with Mr. Yip from the DB. Oh, you've not put up your hand. Madam Choi. Madam Choi Shitwa. We'll start with Ms. Choi. 1 minute. Thank you. Regarding recommendations 8 and the provision about, love among, young children. According to the UN Committee on Children's Rights, in December last year, they published a general, comment regarding the question of age of consent. We should first of all consider parallel protection and also the development of young children, so that sexual relationship or sexual activity based on consent for these children should not be a criminal offense. We also agree with that. Next, Madam Chan. Regarding recommendation 8, we agree with the recommendations of the UN Commission. And for those children aged between 16 and 18, should we give them further legal protection? If you already define the age of consent at 16, then you would. I don't think we need other legislation to restrict their sexual autonomy. Next, Dr. Chang. No. Madam Choi, you go first. We agree with the other two deputations, and I will not repeat myself here. My third point is, how do you identify or determine whether for an MIP, how would he or she indicate consent or otherwise? To deal with this issue, we would need to start with the frontline persons like the carers, the law enforcement officials, and the judicial officers. To put it simply, the question is whether or not we have enough social workers and people who have experience, social workers who have the experience in dealing with such cases. And even the carers, do they have the experience? Have they been trained? And I'm talking about sexual violence here. And next, I'd like to come to the policemen. Do they have the understanding? Would they be assisted by clinical psychologists? I understand that such resources are there, but I think we have better protection for children. I'm not saying that we should cut the resources for taking care of children, but I don't think we're doing good enough as far as protection of MIP is concerned. Dr. Cheng. I'd like to respond to Dr. Mr. Jeung's point about MIP. For moderate or minor mental handicap person, they should be able to indicate concern. But regarding evidence, very often these persons may not be able to proactively, testify. They may, tell the family members what happened, and it's usually family who are reported to police. So for hearsay evidence, for the MIP, sometimes they are mentally handicapped or they are mental patients. So when we believe that these are the three areas where the LRC should consult the views of the clinical psychologists. Next, Dr. Ho. I'd like to go back to Mr. Chen's point about those aged between 16 and 18. First of all, we have to look at the principle in the law. Why do we have the legislation? The purpose of the law is to protect people. If we agree that the Convention of the Rights for Children is for those below the age of 18, for those who are between 16 and 18, should there be a law to protect them? That's the first thing we need to think about. And secondly, in reality, when we deal with suspected cases of child abuse, the procedure is that the welfare workers will only handle cases for those below 18. There are cases involving children between 16 and 18, and these children are not protected by the law. We we believe that there should be collaboration among the police, the welfare workers, and the teachers. But as far as this age bracket is concerned, the law is not giving them protection. And sexual offences, it's possible may affect people between the age of 16 and 18. You think there's a need to offer them protection? Okay. Mr. Chen. Thank you. Regarding puppy love, I will not repeat on that any further. The chair mentioned about gender equality and that we should not have discrimination based on gender or sexual orientation. I'd like to ask the LRC member whether in respect of sexual violence offences like sexual offences or sexual violence, irrespective of sexual orientation, for sexual offence cases, very often semen is used as the major evidence to prove whether or not there has been sexual aggression or violence. But if it's sexual, violence by one female against another female, how in the law can we determine or how can we help the court to make a judgment in respect of such cases to determine whether or not there has been sexual offences involving women against women? Anyone else? Mr. Leung. Thank you, Madam Chair. I'd like to respond to the points made by the other deputations. you believe in the law, you think that the law is the basis of ethics or ethics is the basis of law. I think this shows that there is this urgent need for law reform. Early this morning in Kwun Tong, an independent music parlor, someone was arrested because they don't have the visa, and the police also, conducted a raid on this music parlor. Well, we all know that this music parlor is operating without a license, and the musician in charge, the musician performing there, did not have a visa to work in Hong Kong. But if you ever consider that when they apply for such licenses, it is so difficult, Mr. Leung, we must come back to the issue that we are deliberating on. Ms. Lam. I think other than enacting legislation, in premises where people work with children, we must have a register to enable people to check whether or not they are sex offenders. Otherwise, many young children will be violated. Also, in the light of the incident at the Cambridge Home for the Elderly, it was only because of that more people are not aware of the problem, and there is a demand for reform. This is because children and people who are MIPs, when they are subject to such a lot of hurt or trauma, it is unfair to require them to testify in court. And it is even more unacceptable that the perpetrator was able to get away. That is very unfair. Well, several members are now queuing for the second round, and Ms. Kwok for her first round. I may need to extend our meeting by 15 minutes so that members who would like to ask questions can finish with the questions. Ms. Kwok, so it's your first round, so I will now give you 3 minutes. Chairman, I agree with the other members and the deputations who pointed out that for those aged 13 and 16, if there is mutual consent, the sexual activity they engage in should not be a criminal offense. I'd like to ask the LRC what is the view on that. Also, the question is asked, how do we protect those between 16 and 18? What are the views of the LRC? And another deputation pointed out or asked about the explosion of information on the internet. If someone deliberately try to groom young children or induce them to access certain pornographic information, as a result they become curious and would not object to being sexually violated. Under such circumstances, how can we protect such children, especially for people who try to induce young children online? Also referring to paragraph 6 of the paper, it is suggested we should not differentiate between sexual offences involving penile and non-penile penetration. I think this recommendation is reasonable, and I'd like to know about the views of the LRC. Either Mr. Ross or
Elizabeth.
Number of matters raised here. We can see from the deputations that even amongst the deputations there's a difference in view as to whether sexual activity towards 16 to 18-year-olds should be criminalised or not, which is basically in line with our views that the matter should be referred to the public for consultation. Madam Choi raised the second issue of whether the MIP definition is in line with the clinical findings of what an MIP is, or an MPI rather. And it may be that just simply by taking the definition from the mental health ordinance, that's not reflective of the clinical findings of when a person is mentally impaired. So we'll take that matter on board to the Commission to see whether the definition should be refined further than just adopting the definition in the mental health ordinance. Mr. Chan asked whether in a practical sense, how female-on-female sexual violence can actually be prosecuted, because whether there's a male involved, semen samples can be readily obtained. While I don't have the technical expertise, as I understand it, DNA samples can be taken from the body of a female victim to see whether any, if there's a perpetrator's DNA is present there. So that it may be that matters can be dealt with on that respect. Lastly, Ms. Quat asked whether how to protect people against grooming. You can see from the recommendations that one way to do it is to try and get in early instead of charging people with an attempted sexual offence. We suggest that having a grooming offence itself, and suggesting also that we use undercover police officers who can pretend to be people under 16 or children, and have a special offence to attack grooming at an earlier stage than before the perpetrator actually meets up with the child.
OK，跟住就係議員嘅第二輪。
Second round of questions from members. We have Mr. Holden Chow, Dr. Fernando Cheung, and myself. 2 minutes each, please. Mr. Holden Chow.
So, simple question for the Law Reform Commission. I think many of our colleagues here have grave concern over the fact that the persons with mental impairment, they will have no ability to testify at court to prove their consent. So there would be one suggestion when you when you're deciding to have the new offences on to protect the persons with mental impairment, have you actually considered introducing the absolute liability on the sexual offence on the persons with mental impairment, at least on the penetrative sexual activity? So if you do that, that would simply protect them or avoid them to give evidence at trial, and that would avoid a lot of trouble. It could be very strict, the absolute liability, but I think that would be a best option to protect the persons with mental impairment. So I would like to see whether you have actually considered that when you decide your new offences.
Okay, Mr.
Thanks.
Rob? Yeah.
We haven't considered that. Obliged for Mr. Holden Chow's comments. We haven't considered whether absolute liability should be sheeted to a person who has a sexual or penetrative offence on a person with mental impairment. Thank you for the suggestion. We'll take that back to the Commission. We haven't considered it though.
Well, I think if we have introduced if we attempted to introduce the absolute liability on the sexual activity on those children, why don't we just simply consider introduce the absolute liability on the sexual activity with the persons with mental impairment? So that would save them from giving evidence at trial. This is the best option to protect them. Save us a lot of trouble. Yeah. Thank you.
Mr. Ross? Yeah.
Yes, we'll take that suggestion on board.
More than one recommendation on that, okay? 第二位呢就係阿張超雄議員。
Second, Dr. Fernando Cheung. Chairman, today we are talking with sexual offences involving children and persons with mental impairment and the relevant law reform. And this is important in protecting these people. The later we carry out the reform, justice cannot be administered. We have seen incidents such as at the Bridge of Rehabilitation. We are of the view that the current legal loopholes must be plugged as soon as possible. We heard that the DOJ would discuss a draft reform on hearsay evidence, but it should go beyond that. The community LLC also proposed recommendations, and the LLC said they have to wait till all the 4 reports are completed, and we are now just at the consultation for the second. So how long would it take for all 4 reports to be compiled? We cannot just wait forever. We don't have any government officials today. We don't have anyone from the DOJ or even the Labor and Welfare Bureau or Education Bureau, which have to do with children. Apparently, they have no responsibility at all. Isn't law reform the job of the government? And the government has legislative power, but when it comes to a reform, they are delegating to the volunteers. Well, I do have a lot of respect for you. I suggest the panel to write to the DOJ urging them to drop a timetable on sexual offences and the relevant reform, or else this would be injustice to victims of the sexual offences. I'm not sure if other members would agree. We cannot tolerate this casual attitude. In my opinion, we should not wait till all the 4 reports are completed. The government should begin work as soon as possible, even though there are still areas of debate. But in general, we are at least going in the right direction, and a reform is imminent. So we really need a timetable. Mr. Lam Kwok Hong raised his hands. Do you have a question? I have drawn the line, but I will give you 2 minutes nonetheless. I have a question for the LRC. What is your view on the very slow progress? Do you think you should speed it up? And the government's policy making should be based on priorities. Our government often reforms the law, and they would resort to interpretation from the MPCSC. The Oath and Declaration Ordinance, it has completely changed after interpretation. The DOJ spends a lot of time disqualifying legislators. If they spend 1/10 of the time to deal with the issues we talked about, I think they would be gone already. I think the views are very clear on whether offences should be made criminal and protection towards PMIs. The views are very, very clear. So I have a question for the ALRC. Do you think the government should speed up their work? And do you think it's appropriate to wait till the 4 reports are compiled? Mr. Ross, please.
Well, primarily,
primarily, Dr. Leung, the matter is in the hands of the Department of Justice if they wish to speed up the implementation of the report, or if they wish to go ahead of the report. It's a matter really for them. I should, as Mr. Leung Kwok Hung acknowledges, the LRC is actually a body which makes recommendations on law reform, doesn't actually implement them. So it's up to the administration to decide whether these recommendations will be adopted or not. We meet regularly. There's around 8 members of our committee, including officers from the police, from social welfare, who sit with us. So we have been going steadily without interruption for all this time.
Mr. Ross， 亦都多謝咁多。
First of all, I'd like to thank Mr. Ross as well as the deputations. We have indeed invited in writing the government to come. So we regret the fact that no government officials are here today. We will take that on record. Barring any objections, we will write to the DOJ on how they will follow up. And for the open hearing in 2013, we spoke on this topic as well, and hopefully we can achieve some progress. The ALRC faces great restrictions in terms of resources and other things, but I think resources might not be the main reason. This issue involves moral judgment, etc. But having heard what the deputations and members said, I think it would be possible to strike some kind of consensus. We should urge the government to speed up, and we should urge the LC to arrive at consensus sooner, and the LLC could not address those questions. But in terms of graphical version of the information, they agreed to the recommendations from deputations. In terms of hearsay evidence, hopefully we can achieve a breakthrough as soon as possible, and after that it can be discussed at this panel. And that way we can urge the government to respond as well. So we are a little behind schedule, and I decided to extend this meeting by 15 minutes, so hopefully you have all offered your views. If you have any more to say, as I said, you can submit them in writing. We will also write to the government, and hopefully with the right collaboration, we can facilitate the legislative efforts. Once again, I thank you all for coming, and you have offered some very valuable views, and we'll follow up on that. Thank you.